Page 3 now. A South Carolina prosecutor is working with law enforcement to seek an indictment next month from a county grand jury on the murder charge against former North Charleston police officer Michael Thomas Slager. Scarlett Wilson, prosecutor for Charleston County, says that while the former officer has appeared before a magistrate on the charges, only a circuit judge can set bond on a murder charge in South Carolina. Slager is charged with murdering in the shooting death of Walter Scott after a traffic stop.
The fact that we've got an arrest and a charge, what we want to do, and as we usually do, we want to see the process happen. We want to see the trial. We want to see a conviction. Those are the things we're looking at. We can train folks with every possible training we have, but you have to change hearts and minds of people. And that's going to be the bigger process that has to be dealt with. We have a culture here that is all right. When you hear the term that Black Lives Matter, those folks that are in position of authority, first they have to believe that. And if they don't, they will continue to perpetrate this kind of tragedy in the community.
Family members say Scott may have run from Saturday's traffic stop because he feared going back to jail over unpaid child support. Slager will have an initial court appearance in August. Joining me now, attorney and legal analyst Abbas Khazarjarian.
Hi, TJ. How are you?
I'm doing well. And yourself?
I'm doing great. Thank you.
Let's talk about the facts of this case. Under certain circumstances, it's permissible for someone to use lethal force, particularly as a police officer. What are those types of circumstances, and how do they apply to this case?
Well, there are, very few circumstances when lethal force can actually be used, and there are a couple of cases that came from the Supreme Court that would be governing in this particular kind of situation. The first one is actually one called Tennessee versus Garner that came out of the Supreme Court in 1985. And the Supreme Court instructed, and they said that when trying to prevent the escape of a suspected felon, deadly force can only be used if it cannot be shown that the escape of this suspect is absolutely necessary and that the law enforcement officer had probable cause to believe that the suspect poses significant and imminent danger of causing serious bodily injury or death to the law enforcement officer or those around them. And I think under these set of circumstances, it would be hard to show that imminent and significant threat of deadly force by Mr. Scott. Now, the other case that will be governing is the reasonableness of the force used under a Fourth Amendment analysis and a search and seizure. And that case was called Graham versus Connor. And in that case, the Supreme Court instructed, and they said, well, in these kind of situations, it's a case-by-case analysis, and you have to use a totality of the circumstances. So I think the three facts that came out of this specific case that would really be controlling are, first of all, let's look at what is the crime that Mr. Scott was being accused of, and it was a small traffic violation. The second one would be, what was Mr. Scott doing when the force was used? And if you look at the footage that was released recently, he was fleeing from the law enforcement officer, Mr. Slager. And of course, the most significant factor is, what was the force that was being used? And the force in this specific instance was the fact that Mr. Slager shot Mr. Scott not once, not twice, but 8 times. And I think that's going to be significant.
And there's a serious question of whether he's going to be able to effectively argue any type of self-defense. And I think the video is going to be significant in that regard. How important is the video in this particular case, and what would have happened without it?
Well, I mean, the video so far is everything because it's all the evidence, and the reports that came out of what happened almost changed 180 degrees, because at first it was alleged that Mr. Scott was struggling with Officer Slager, and that's what caused the shooting. And I think but for the video, it would have been a hard struggle to prosecute Officer Slager. So I think it's absolutely everything. And as far as self-defense goes, in order to prove self-defense, you have to show imminent harm as far as the person that is being shot or killed. And there was really, on that video, it's hard to show how Mr. Scott was an imminent threat, in order to create significant bodily harm or death to the officer. So that's the analysis on self-defense, I think.
Absolutely. And how do you see and compare and contrast this with regard to something such as Ferguson?
Well, I think the facts are they're similar and they're very different at the same time. But I think the most significant fact that's come out and the learning process that we've had coming out of this, out of Ferguson, and you look at Eric Wagner out of New York, and of course this is I think that the other races, but for the white demographic, is underserved in the law enforcement population. I think the New York Times actually released something, and taking Ferguson as your particular example, the law enforcement over there has 83% white officers, whereas the population of Ferguson only has 29% white population. Whereas, and it's very, very similar to North Charleston. And in North Charleston, the population, if you take the whole demographic of white people in that population, is 38%. In the law enforcement, it's 80%. And I think that's a serious learning curve as far as going forward for the law enforcement agencies throughout the country, because the racial tension that is coming about as a result of these shootings is of concern.
You know, one of the big challenges with that, though, is when you stigmatize an entire police force with the actions of somebody like this, how likely is it that people in the black community are going to aspire to become police officers? Thank you, Abbas.
My pleasure.